well, have you tried stop smoking? She says, well, I don't smoke. She says, well, maybe you should give up drinking. Why? I don't drink. Well, what about fatty foods? And I don't eat fatty foods. And the doctor says, well, ma'am, you're like a ship with no ballast. You've got nothing to dump overboard. In other words, so if it's true that the U.S. really is not going to go significantly further on reforming surveillance, and that, let's say, the other two things that I don't want to spend a lot of time on today, which are ECBO reform and the Judicial Redress Act, which would give Privacy Act rights to Europeans, which is it's important, but it's a limited set of remedies. If those things are not adequate to address European concerns, and 702 and those national security programs aren't going to fundamentally change, then what does the U.S. have to give? And doesn't that mean that even though the Schrems decision is about surveillance, that the negotiations about a new transatlantic trade deal and a new safe harbor may inevitably end up requiring concessions from the United States on the commercial privacy side? That's what I want to talk about. Janice?
Yeah, I think that's a really interesting question, and you do wonder what the U.S. does have to give and whether at some level this isn't sort of ultimately driving towards a world in which you just have data localization and kind of almost a de facto requirement, if not an explicit one, that U.S. companies keep their data housed in servers in the EU. But obviously the U.S. would, certainly the U.S. companies wouldn't want that, and I don't think the U.S. government would too, but it is hard to know what they could give up. I think that Congress could fashion some redress rights akin to whatever U.S. citizens have, whatever those may be. I'm not entirely sure on the specifics. We know that there are certainly great limits on that. Maybe that would be enough, but I don't know, especially since one of the significant things in the decision is that in addition to sort of declaring safe harbor dead, the court also said that the individual privacy authorities of each country has this right to kind of review these global agreements that, like, the EC would enter into with the US for the transfer of data. And that's a new thing, and that's really significant because, even if the US and the EC come to some new agreement, and even if this court should bless it if it should ever come up for review, any individual country, right, Spain, anybody could say, I don't think it's good enough. And so it is very hard to know how this all ultimately shakes out. I figure, given that, I think that's just this wild card. So I don't have the answers, but I think it is very interesting, to start to see more of the interweaving of the commercial privacy and the national security interests in certain places like this opinion.
I do think some of the things that you mentioned are significant and can and should happen. The Judicial Redress Act granting non-U.S. persons rights under the Privacy Act, I believe it should happen. It isn't that controversial, although Congress is not getting anything done, including non-controversial.
Well, it's passed in committee.
Yeah, okay, but getting
and I'm not aware of anybody opposing it.
Yeah, so hopefully that will happen. There's also another statute that has been act that's been proposed by Senators Hatch and Coons, the so-called LEADS Act. I don't remember exactly what it stands for, but the purpose of it is essentially to reverse the decision of the Southern District of New York to compel Microsoft to produce customer communications stored in servers in Ireland pursuant to a search warrant served in the United States. Microsoft, with the support of the tech community and the telecom community, I submitted a brief in support on behalf of AT&T. Microsoft has resisted producing the customer communications on the grounds that these are not its records, its customers' records. They're extraterritorially located. Microsoft says the metadata are business records of the company. They did produce that domestically. That was not considered by them extraterritorial. So one of the things...
And if I may, my understanding, just because I think people have a hard time getting their minds around the LEADS Act, my understanding is the reason that someone like Hatch is proposing that is they're concerned that if the U.S. law enforcement can use warrants to compel production of data stored overseas, that Russia could try to do the same.
And they do,
with respect to data that's stored here. So that's perhaps useful context.
Right. And so this is something that the U.S. has done, I think, thoughtlessly to counterproductively and unnecessarily fan the flames of these European concerns. So if the White House tells the Department of Justice, don't litigate this case anymore. Use the Mutual Legal Assistance Treaty process, the MLAT process, which is available. There is a treaty in force between the U.S. and Ireland. Get it that way. That would respect the foreign privacy interests, foreign sovereign rights, and so on. So that should be done. But I'm not sure that the U.S. really needs to be thinking in terms of concessions here. The fact is that the Europeans don't understand our system, and while it's not perfect, it is substantial.
Well, okay, so a question from the audience?
So this was a decision of the European Supreme Court. So how can it be undone? Like, it's their Supreme Court. How does European law legal processes work?
So this is, let's pivot from this to the U.S., because the point here, as I understand it, is ultimately, remember, safe harbor was essentially, it's a treaty, essentially, that allowed data to be exchanged between European companies and or European users and American companies, or European companies and American companies. And that allowed them to have protection from enforcement actions in Europe. And that treaty or agreement is now gone. And so the question now that's before the Congress and the administration is, what will replace it? The administration is going to try to negotiate a new deal that's going to be perhaps part of the larger free trade agreement. In order to do that, my strong assumption is they're going to need Congress to do certain things. We've already mentioned a few of them. ECFA reform, the Judicial Redress Act, I think those get us seats at the table. But they may not be enough. And the point here is the Europeans have had longstanding complaints about the adequacy of U.S. consumer privacy protection. I agree with Alan that it's largely because they don't understand our system. And that if they were more honestly willing to assess it, they would see that the FTC is really quite active. Indeed, probably a lot more active than European data protection authorities. But my question for the panel is, I'm just trying to predict or understand what might happen in the future, is really, does this decision, or let's not even say the decision, let's say, does the death of safe harbor and the need to negotiate a new agreement, setting aside Schrems and its merits and what's in it and so on, does that change the equation in Congress? Does it mean that the FTC's calls for legislation since 2000, which have gone nowhere, or the administration's privacy bill, which came out, which was supposed to come out around the time Edward Snowden's leaks, which then got sidelined for years and was finally released last year and has gone nowhere. Janice, does that mean that you think we might see something happen in Congress?
I mean, maybe I just don't have enough imagination or something like that, and I just see the world as it is today, and I find it hard to imagine as it might be. But I don't really see that. I don't see that happening, and I don't know. And my sense of it is that you've got a couple in Europe too, just as in the United States. Of course, we have different players. We have Congress, we have the administration, we have private sector. We have the agencies, like independent agencies. In Europe, you have the EC, which is kind of like their administration, their executive branch. Yeah, and then you have the courts. And my sense is that the Commission, the administration in Europe, is probably less up in arms about all this privacy than the court was. That they were not eager to strike down safe harbor the way that the court was, and that they would like to come to a deal. So it may be that we get some kind of a deal, because remember, the person that will be at the table will not be the court. It'll be the European Commission or representatives of the Commission, and then they just have to hope that if they do reach a deal, that someday it doesn't wind up in front of the court and invalidated. So I don't have a crystal ball, but my sense is that we'll see an agreement that will see more reforms, whatever they may be, in terms of judicial redress for non-U.S. persons, etc., but more on the national security side and less on the commercial side.
It's important to understand the actual failure that results, that the court found that resulted in the invalidation of the safe harbor was not actually a failure in the United States. It was actually a failure of the Commission. So while I don't think that the analysis is compelling, what they're saying is, what the Court of Justice is saying, is that the Commission failed to adequately assess the adequacy of the U.S. privacy regime, that they failed to do it in 2000 and that they failed to do it sufficiently adequately periodically since 2000.
In other words, that the European Commission should have negotiated some kind of update to safe harbor?
I'm not sure that it's a question of negotiation. It's a question of, have you reviewed it substantially enough? Have you reviewed the U.S. system profoundly enough to make a judgment? Because the judgment is of the Commission. The Commission is the one that, on behalf of the European Union, was empowered to make a judgment that the United States system under the safe harbor regime was adequate, that is to say, substantially equivalent to the European regime. The irony here is, right, because Baron's thesis for this panel, what we've been talking about is this intersection between national security and commercial. The irony is that the European Commission is not empowered, or to use the common term, not competent in a jurisdictional sense, to assess national security issues. That is not a competency of the Commission.
Meaning something that's been delegated by
the member states to the Commission.
Or by the privacy, I think probably all of the privacy authorities of the individual member states in Europe, which now will have this authority to review whatever agreements there might be between the U.S. They also don't have it. So there are a lot of ironies here and contradictions.
Well, so I want to pick up the pace and really focus on U.S. regulation. If there's a question just to wrap up about the ECJ decision, please.
Follow-up. I appreciate your clarification about the court opining about the European Commission versus the U.S. system per se. Was there, I guess, what we would call dicta or any other intimation, however, that they didn't really think much of the U.S. system?
There was, by my reading and recall, there was a quote from the Advocate General, which is in essence an advisor to the Court of Justice, who in turn reviewed the pleadings submitted by Mr. Schrems in Ireland, and so they really just it's a quote from the advisor, the Advocate General's opinion to the court that looks at the pleadings in Ireland, and they say that the U.S. surveillance was massive and indiscriminate, which is really in the nature of an allegation. So there's been no finding to that effect, and but it was an allegation expressed by Mr. Schrems in his pleadings in Ireland, picked up by the Advocate General and quoted, not more extensively, I don't think, than what I've just described in the Court of Justice's opinion.
It's a really terribly written decision in the sense that it's Brussels speak. It's very hard for Americans to really look at it and process it. I mean, it's not written the way you would expect an American legal decision to be written, where the points are, it's maybe long, but you can find them. It's really hard to find exactly what it is that that the decision rests on. It is there. It's a different style of writing. But I want to move on. So my last question about this, just to wrap up, is this administration, for the last 7 years, for better or worse, has resorted in many instances to executive action or to trying to address things through international agreements that it couldn't get through Congress, so rightly or wrongly. And one of the concerns that's being raised about the Trans-Pacific Trade Partnership and the Transatlantic Free Trade Deal is that the administration could essentially create regulatory mechanisms bypassing the normal legislative process. So is there a possibility here that nothing will happen in Congress, but that the administration will tack on essentially a new form of part of what it wants for commercial privacy regulation in that free trade deal and present it to Congress as an up or down vote, and just assume that there's enough momentum to get the whole thing through, and that could be the way that U.S. privacy regulation changes?
I mean, I guess it's so early; it's hard to say. I guess I couldn't rule it out. I haven't heard that previously, but the safe harbor decision is a week old, or like just over a week. So, it's an interesting idea. I don't feel like so far in at least with the Asian trade deal, you've seen the administration really trying to do a lot on privacy. I mean, that's not part of that deal. But I suppose with the safe harbor decision, I guess anything is possible. But I really don't have much more of an opinion on that.
So that it's an ironic question, because the concern early on was the opposite. that the
Yes.
that the TTIP, Transatlantic Trade and Investment Partnership, would serve as a vehicle to constrain European privacy regulation. That the Europeans would be obligated to concede a more unrestricted flow of data as part of the liberalization of trade flows under TTIP. So the concern was, and why was that concern? Did they have that concern? Because people like me and others submitted comments to the U.S. Trade Representative that solicited comments on behalf of the high-level working group. I can't remember the term now, but there was a working group established between the European Commission and the United States, U.S. Trade Representative's office and the European Commission, I can't remember which office, but to promote jobs and jobs, economic growth, and innovation in the respective jurisdictions, EU, United States. And so they solicited comments. What do you want to see in the TTIP? And a number of parties, as I said, myself included, submitted comments saying that this should be a vehicle to liberalize trade flows and for acknowledgement of mutual recognition of the two systems. Different, yes, but oriented towards accomplishing similar data protection and privacy controls. So the original concern was the people in the EU.
Got it. So I'm just sorry, when we let to cover, I just want to move on. So, one more question about Congress. So the Senate Commerce Committee is trying to reauthorize all the agencies under their jurisdiction. There's a reauthorization bill for the FCC moving forward, and it appears that one will be coming for the Federal Trade Commission. It doesn't seem like it'll include a lot of substantive changes. It seems to be the case that Senator Thune really is just trying to, as a good housekeeping measure, put the agencies under that committee's jurisdiction on a regular cycle of getting reauthorized every 2 years, because these two agencies have not been reauthorized since the 1990s. The Federal Trade Commission was last reauthorized back in 1994, which is when Congress narrowed its authority over unfairness by enshrining the 1980 unfairness policy statement. So do you think that going forward that, let's assume that I'm right, that there's nothing really significant in that reauthorization bill, but that it does put the agency on that cycle, and they do what agencies are supposed to do. They go back every 2 years and they defend their practices and they have more oversight. Do either of you think that that might change anything about how the Federal Trade Commission works?
Well, so my opinion is that it probably wouldn't change much of anything. My view, but I was at the FTC, so now in private practice, but you can factor that in if you want to think that I have like a bias or particular perspective. But I mean, I think the agency feels very much like it is a creature of Congress, and that Congress is subject to congressional oversight. I mean, Congress can and does bring it in for hearings all the time on any issue it wants to. And so I think that if it had to be on a 2-year, if it was on a 2-year cycle, it just sort of more of the same. But it's not like Congress is currently constrained, and if it doesn't like what the agency is doing in an area, it's obviously free to hail it in, and does.
So what do you think it means for the agency to be a creature of Congress when the underlying statutory direction that it points to from Congress, which is Section 5, is so broad? It really just says the practices are deceptive or unfair, and that gives the FTC the ability to go after them. Congress, as probably most of you in the room know, in the 1970s, the FTC, I think it's fair to say, ran amok with that authority. The chairman at the time was convinced that they could use that authority to regulate just about anything. And the Democratic Congress at the time went so far as to shut down the agency in the first modern government shutdown because it hadn't agreed to constrain its authority. And so out of that came that deal to constrain unfairness in the unfairness policy statement, which, as I mentioned, Congress enshrined back in 1994 in statute. And then 3 years later, the FTC issued a deception policy statement that has similar limiting principles. But for people like me, and I'll let Alan speak for himself, those limiting principles are both pretty broad themselves, and also I don't see a lot of development of them. Now, it's possible the agency does really think very carefully about it internally, but because it settles every single one of its cases with a handful of exceptions in the last few years, We don't see that. So what we see is this, what is called this common law of consent decrees. And it's hard to know how much constraint really is there upon the agency, other than the agency deciding in any particular case whether they think it's a good case to bring. So what do you think about that concern, Janice? And do you think it's likely to change either from the agency or from Congress?
Well, it's interesting because this is a very common criticism of the FTC, that it's it's entering into these settlements, and I think that the public doesn't necessarily understand the reasoning, doesn't necessarily agree with it to the extent it does understand it, and I think there's some validity to that, in that I think that the way that the agency approaches things is, so the way this transpires is like it investigates a company. It goes to the company and says, we believe that you have violated the law, but we think maybe we can enter into a settlement. Here's the complaint. Here's our proposed settlement. Negotiations ensue, and more often than not, an agreement is reached. And the agency, the FTC, it drafts a complaint, and it kind of does it with a view towards what is legally required in a complaint. And there's not actually that much that is required in a complaint. And it puts out some explanatory statements, but I think there's some validity to the notion that it's maybe not telling you kind of everything, and it's kind of trying to keep it close to the vest. So I think that's kind of the issue of the transparency part of it. Companies do settle, though, and so the agency is not put to the test in the way that it would be if it had to go into court and defend itself. But I don't know what the agency is supposed to do with that aspect of it, because it's the companies are all individually making this decision to settle. That's just, we have as part of our legal system that you can enter into settlements. And so I think you could ask of the agency to just go a little bit further than it is legally obligated to in the interest of transparency. So that's sort of all of that. But remember, too, it is a bipartisan agency by its nature. It's not part of the administration. And I do think that it does feel very much that it is kind of out there on its own. So it's not only bipartisan, and it prefers to proceed on a consensus basis, a bipartisan basis, and have bipartisan votes, but also it feels very much like it's not part of this big administration, and Congress can hail it in. It doesn't have like this huge executive branch backing it up, and so I do think it feels the pressure of the congressional oversight.
So there have been some noticeable departures. I want to develop this before we turn to the audience. It is true that the vast majority of the FTC's cases are unanimous and uncontroversial, but there have been some notable exceptions.
Sure.
Recently, Commissioner Wright, before he left the Federal Trade Commission, issued a number of dissents in consumer protection cases, starting with the Apple case, which is not a privacy case as such. It was about how Apple had designed the pop-up windows in its store such that children could perhaps make unauthorized purchases. But that started a series of dissents from him that culminated in the Nomi case, which was about a company that had made, in its privacy policy online, had promised to provide an opt-out not just on its website but in stores regarding the devices that it provided to stores to allow them to identify repeat customers and see where they were moving in the store by monitoring the MAC address that were broadcast by their phones. So the company failed to implement that. And without getting into all the details of the Nomi case, suffice it to say that it brought into very sharp relief, in almost a law school fact pattern kind of way, what it means for a statement to be material, which is the core requirement of that 1983 deception policy. So, in other words, we're starting to see dissents and discussion at the agency that really hasn't happened for a long time. You have to look back to the late 1990s to see that kind of back and forth. I have a lot to say about it, but I want to know what you have to say about that, and then I want to turn to the Wyndham case.
I think I would commend to everybody's attention who's interested in regulation Commissioner Wright's dissent in the Apple case that Barron refers to. It's a masterpiece, I think, of the importance of doing cost-benefit analysis and rigorous review of agency enforcement actions in addition to regulations. And the argument that is both under the unfairness and deceptive standard, materiality and deception, and in the unfairness standard that Barron referred to that was adopted, I think, in 1980, that there is an express cost-benefit requirement. And so what Commissioner Wright is saying is that the agency is not adequately considering and bringing its enforcement actions cost-benefit analysis and not considering harm to consumers. In NOMI in particular, Wright said, without necessarily believing that the company had violated technical deception, said there's really no harm here. And the impact on a small startup and innovation and new business offerings and even transparency. I mean, what they got stuck for was promising something in their privacy policy that evidently they couldn't quite live up to. So they were being hoisted by that petard. So I think that one suggestion would be that the Commission should take the cost-benefit analytic requirement, materiality and consumer injury, more seriously, not just at the Commission approval stage, but at the complaint, as
investigation.
At the investigation stage. Now, I guess two last things, and then I'll stop on this. One, I think that the Commission ought to engage in this analysis more rigorously at the investigation stage, since there aren't going to be a lot of there are always going to be settlements. People ought to make comments in the comment process when a settlement is proposed.
We filed. And there are a lot of comments filed in the NOMI case.
Yeah.
It's a very interesting, this is the first time that I can think of that in Apple, that happening recently.
Yeah. So then the last point that I would make, and maybe this is a paradox, but there is a division of opinion and ambivalence. On the one hand, getting strict, clear rules from the FTC on, and whatever. We're going to talk about Wyndham next, but clear rules versus this very broad, flexible, elastic standard of unfair and deceptive. Some businesses want, tell me the clear rules. I will follow them. Even if they're bad rules, I will follow them better than no rules. But I don't know that that's the way tech startups think. I think they say, no, give me the broad standards and let me take my chances. And it's permissionless innovation that really has inspired a lot of the tech sector. And they say, you know what, unless I do something wrong, let me just find my own way. And if I do something wrong, if I commit an abuse, then let the FTC come down on me.
Janice?
It's interesting because there's this NOMI case. I mean, it's really, at some level, it's really this little case. It's about this, company. Probably you guys have never heard of it, unless you heard of this case. I know I had only heard of it when, in connection with this FTC enforcement matter, but yet it's generated a lot of controversy in the FTC world and the kind of consumer privacy world. And I think that in and of itself is kind of telling that really the FTC is often so consensus-based that you don't see these dissents that much. You don't see these debates. At least you don't see them out in the open that much. And so even though I don't think that the facts of NOMI, I don't think anybody really is that up in arm about like what this company NOMI is doing, or I think it's really that we finally got to see out in the open some of the debates that do take place on the inside of the commission, where people do understand that the different commissioners have very different perspectives and very different ways of looking at what constitutes a material deception versus not, what constitutes sufficient cost-benefit analysis and not, where do you need to have cost-benefit analysis and where are you not obligated. And so I think from my perspective, that's, I guess with my sort of FTC hat on, that's how I think it's interesting. But the debates do occur inside the agency, but I think in part because a lot of times they reach consensus. You just don't see the disagreements out in the open that often, and then you don't see them litigated that much. Here again, Commissioner Wright had a difference. Thought the agency was wrong to bring the case. Another commissioner, Commissioner Olhausen, thought that it was just an abuse of prosecutorial discretion to bring the case. So I think she was basically saying, I think there's a legal justification here, but why are we bringing this case? But you didn't get to see it play out in court because NOMI itself agreed to the settlement. And so I think that a lot of the criticisms that you see of the FTC do come down to that fact that there is this frustration that you're not seeing this stuff play out in court a lot.
So let's talk about Wyndham. I just want to say about NOMI, because we filed the longest set of comments. It's a pretty subtle case, but it really is worth thinking about. And the shortest summary I could give you is and I've said this before, but I'll just say it again, the whole point of the deception policy statement is not all misrepresentations constitute deception that is actionable by the Federal Trade Commission, right? That was the core limitation that was put in place, with a catch, which is that the FTC still gets to presume that certain statements are material. And in the 1970s, when the case law was developed that led to the policy statement, the misrepresentations that were at issue were ads and warranties, essentially. And to make a long story short, if you put something in an ad, it makes sense. It's an express statement that you're making in order to convince someone to buy a product. It makes sense that that would be presumptively material. And I don't disagree with that. I don't know that anybody disagrees with that. The problem, and the thing that Commissioner White was putting his finger on, is that the internet really did change things, because companies now communicate with their customers in a way that was really unimaginable in the 1970s. I mean, maybe you might have had somebody on the phone who might have said something to a customer, but you had very little of the interaction that is now quite common in privacy policies, Twitter, online help pages. There are many ways that companies today make express statements that are not ads. They're not made with the intention to convince someone to buy a product. And I would say it doesn't make sense anymore to presume that every single one of those statements is material in the same way that you would presume an ad is material. Some of them might be. If, for example, it's a Twitter statement, that to me feels a lot like an advertisement. It might very well be material, but we probably shouldn't presume that it is. We should probably have some level of analysis to see that. And that's just to say that that's an underlying legal question that's pretty subtle, that at the end of the day might be changed by having a new deception policy statement or an update to that, or having Congress finally codify the deception policy statement, which has never happened. And the agency has said that they're not bound by the policy statements, which is true. Those are not binding upon the agency. They're just there for advice.
I'm not sure that they've said that they don't feel bound by the policy
Touchtone,
statement.
1997.
I'm not sure that they have said that they don't feel that they're bound by the policy statements, and I think as a principle of administrative law, they actually, having said it and kind of put it out there in that formal way that they have, I think that they would be bound by it. They didn't have to say it, but no, do you disagree with that?
I think as a principle of administrative law, if it's not adopted pursuant to some...
It was, though.
Oh, was it notice and comment?
Yeah, I mean, it was adopted by commission vote, and it's certainly, to the extent it matters, I think they put it in the Federal Register. I don't know if they put notice and comment on it.
Well, I'll just give you, this is a little bit wonky, but just to give you, just because I've dug into this, in 1997, there's at least one case, which is Touchtone. It's two cases, actually, I'm sorry. So the case that I'm thinking of is a case involving eBay, where, make a long story short, the commission brings a case involving business-to-business deception, where a particular company had essentially scammed eBay, and the commission brought a case and said that's deception. The minority commissioners dissented and said, we don't think that's what the deception policy statement says, it's supposed to be for consumers. And the commission says, well, that might be right, but we're not strictly bound by the terms of the statement. So they can go beyond that. And the point is just to say, this is an area where there's going to be a lot of litigation. Congress may get involved, and it may be an area where you see more questions asked of the agency.
Yeah, but so let's just so we put aside that question of whether the agency is in fact free to kind of ignore what it said in these policy statements, which are sort of supposed to almost be like their own, like their touchstone, as Barron said, kind of their own internal constitution. But so the Wyndham case was about whether it's just a decision by the Court of Appeals for the Third Circuit, and that court was looking at whether the FTC had authority to declare certain cybersecurity practices to be unfair, and what the FTC would say is unreasonable and sort of inappropriate cybersecurity practices. And the court said, yes, it does, the agency does have that authority, but it wasn't deciding whether Wyndham had in fact engaged in whether its practices were unreasonable. And it kicked it back to the district court, where I think this issue that Barron has raised could very well come up, which is there's this unfairness claim, which has to do with just regardless of what Wyndham said it would do, just were its practices unreasonable, unfair. And then there's a deception claim, and this gets into what did Wyndham tell its customers in its privacy policy, and you get to Barron's point, which is, well, okay, it made some statements, it or NOMI made statements. Lots of companies, they make statements in these privacy policies under traditional commission thinking. Once it's an explicit statement, it's presumptively material, meaning kind of important to consumers, might affect their decision, like whether to book a reservation at Wyndham or at Hilton. It's right, that presumption goes back to a very different context. And so I do think that the underpinnings of that presumption are on somewhat shaky ground today, because I think privacy policies are just very different. They're written for very different reasons.
And so just to be clear, why this matters, this is the major hook by which the FTC enforces privacy and data protection in the United States.
So I do think it's really important. I think that it's very appropriate for courts to reconsider that. It is appropriate for the FTC to reconsider it. It's also appropriate for Congress to reconsider it. I would just make one point, though. It's more of a policy point than sort of this legal one, which is that I think of the current the privacy regime, legal regime that we have for consumer privacy today. It is very dependent on FTC enforcement, and FTC enforcement in turn is very dependent on this deception power. So in the data security area, it does use in fairness a lot, but in the privacy area, it's really mostly using the deception authority, not entirely.
Do you think that that's likely to change?
I mean, it hasn't changed. So we've had President Obama with his Democratic chairs and his majority commissions. I mean, we're getting near the end of this 8-year cycle. I mean, who knows what the future holds? And we haven't really seen that change all that much. And so I'm not saying it couldn't change in the future, but I mean.
But the agency is definitely becoming more aggressive.
I think it has become more. But if you really look at how many cases has it used unfairness and privacy,
was Sears unfairness?
No, it was deception.
How could it have been deception when the company disclosed it expressly? Sears
you're
was,
right.
Sears was
okay. Maybe I'm getting that wrong, but that case goes back to 2000. Like that was in 2008, 2009. No, it must be 2009 case. That case was fairly aggressive because Sears was like doing some kind of funky program. Was doing
we're going to run out of time.
Yeah.
I want to take questions.
Anyway, I think your point is a valid one, that you'll see these issues are being raised. I just think that in the deception arena, because we don't have kind of the comprehensive privacy laws that some have pushed for, like the Commission, the FTC itself has pushed for, you are kind of resting on deception, and then maybe it does give more weight to what a company says in its privacy policy, whether, right. So anyway, that's just my point.
So I want to say one more thing about Wyndham, take a question about the FTC, and then turn to the FCC, and then take questions from the audience. So you mentioned the Third Circuit decision. So the Wyndham case is really important because it's the first time the agency is actually really litigated on its data security approach, and that by extension also affects its privacy regulation. Most people interpreted the Third Circuit decision as a win for the FTC. I'm not so sure, and Gus Hurwitz wrote a great piece about this, saying in Wyndham the FTC won a battle, but perhaps lost its data security war. The underlying point of this is pretty subtle. We don't necessarily have a great deal of time for it, but to summarize, basically it reads the decision very carefully and says that actually what the court says is that it agrees with the agency that its guidelines and its prior decisions, really strictly speaking, are irrelevant to assessing fair notice, that what's fundamentally at issue is interpretation of the statute. And how that goes is not actually clear. It means that the agency, for as much as it talks about its common law of consent decrees, really what it really is doing is just opining in each and every case anew on what the statute means. Now, so just briefly, what do you think about this? Do you think that this perhaps opens the door for the agency to, as that particular litigation proceeds from this very early stage, for the agency to perhaps lose on its interpretation, or for the court to reinterpret the statute?
Yeah, well, the court directly says that because the FTC has not adopted a rule or made a clear pronouncement on on its interpretation of its data security authority under unfair and deceptive, that it really falls to the court on its own initiative to interpret unfair and deceptive in Section 5. And in contrast with an administrative agency empowered under a statute, where courts will defer to any reasonable interpretation that's not foreclosed by the statute, The court said, unlike an administrative agency that can go with any reasonable interpretation, whether or not it's the best one, the court is obligated to, in the absence of an administrative determination, is obligated to reach the best interpretation. And that is more confining for the executive authority, because under the Chevron case, which allows agencies to exercise certain leeway interpreting statutes, the court says no. It falls to us to give it the very best possible interpretation, and not one that might be reasonable in the eyes of the agency. So it is confining.
Right. So things could change. Janice?
I agree with Alan says. I mean, it's basically saying, it's sort of this trade-off. It's saying, on one hand, the FTC doesn't, it was really saying to the FTC, you don't have to provide a ton of notice to companies in advance about what you think is an unfair data security practice, but at the same time, your opinions, FTC, really don't carry a whole lot of weight. The court's going to decide, and so that's kind of the trade-off. It's like, and so it'll be interesting to see how that plays out, because I think that concept was, to me, that was like the newest thing in the Wyndham decision that we hadn't really seen before.
So the courts in the U.S. could shake things up, and perhaps that would actually play more of a role than the Schrems decision does in driving Congress to do something. Questions on the FTC from the audience? Anything? Because I want to quickly just cover the Federal Communications Commission. So, there's been a lot of consensus in the United States for a long time. We were moving towards having the FTC become really the privacy regulator, more of a data protection authority akin to what the Europeans want, one agency with general competency. Ironically, the Federal Communications Commission, as everyone knows, decided to invoke Title II to regulate broadband providers, which has the unintended consequence of stripping the Federal Trade Commission of jurisdiction over broadband providers, as well as over any other services that the FCC may regulate as common carrier services, like interconnection and any other aspects that the agency might end up regulating, because the current Section 5 stops the FTC's otherwise general authority at common carriers. So now the FCC is moving forward with a privacy rulemaking. They declined to impose their existing privacy rules from the old telephone cable days. We're going to see something come from the Commission, I'm hearing, early next year. I'm also hearing that they're scratching their heads trying to figure out what it's going to be, because they're not really a privacy regulator. They don't really know exactly what they're doing. So thoughts on where the FCC may head and how the two agencies may interact with each other in the future?
Well, it's certainly an interesting development. I've seen this. It's really basically about a year now since the two agencies began both, I think, kind of getting into each other's territory, really, because the FTC began to start bringing some enforcement actions against companies that we think of as kind of under the FCC's authority, like cramming decisions, mobile cramming decisions against AT&T and T-Mobile,
the throttling
case. And then at the same time, the reclassification decision, the open internet order, was kind of coming to a head. And you began to see the FCC also, just even before that, start getting really interested in privacy. And so there is this overlap. That's the nice way to put it. Some might say a clash of the two agencies.
Or, as Josh Wright said, the FCC stole the FTC's jurisdictional lunch money.
Yeah, so it is very interesting. You don't see, I mean, there definitely is kind of a turf battle going on, I think, between the two of them. But the reality is that I think of it as like I think of it in sort of like the FCC saw this bright shiny object, and the bright shiny object was privacy, because privacy is really interesting. It's I think of just more and more importance in the world as just the way things are going, and I think it wanted to get in on the action, and it has found a way to do that. But the reality is it has stripped the FTC of authority over broadband providers now that broadband service is Title II, common carriage. But at the same time, before a year ago or so, the FTC was not actually utilizing that authority all that much. I mean, it was about a 10-year period that it had authority over broadband providers. So there's this Supreme Court decision in, I think, 2005 called Brand X that from which that authority would sort of an indirect result of that authority, and yet maybe I'm getting the years a little bit
That's
off,
right.
but okay. And really, you didn't see a lot of enforcement actions, and so I don't know that the practical effect is all that great. I think it's more that you now have two agencies that are in this same arena of consumer privacy, and will they come to the same conclusions, or will their approaches be inconsistent, and what effects will that have on the companies that are subject to regulation, or will the one agency, what it does, influence the other? Will they almost like be battling to be right now, like who is the more aggressive privacy enforcement agency?
Indeed, you could see one-upsmanship. I mean, it's just
Yeah.
worth pointing out that in the 1970s, one of the things the FTC did with its unfairness policy was to establish public policy in other areas, to point to rules and say, well, that's basically per se evidence that something is unfair. It's not difficult to imagine the FTC pointing to what this new set of rules that the FCC might come up with. And let's say, for example, it requires opt-in consent or for broadband providers to obey do not track mechanisms or whatever. It's not hard to see the FTC, despite the unfairness policy statement, essentially pointing to those and essentially incorporating public policy that's created by the Federal Communications Commission into its own enforcement action. So that's one way you could see a kind of one-upsmanship and for the agencies to change.
So what it really calls for is presidential leadership here, and there ought to be a coordinator in the White House or appointed by the president to reconcile all of this. So you might say, well, isn't the FCC independent? Isn't it the FTC independent? And isn't the Securities and Exchange Commission independent, which also has authority here, and the Consumer Financial Protection Bureau, aren't they all independent? Well, yes and no. Yes and no. The FTC has gotten into the Securities and Exchange Commission's bailiwick by bringing a data security case against Morgan Stanley, or investigating, but then dropping. So what is the president's responsibility and authority to avoid this overkill, this double teaming? And okay, so it is true that these agencies are independent, but the commissioner, the chairwoman of the Federal Trade Commission, the chairman of the FCC are both serve as chairs at the pleasure of the president. And we've seen in the case of the Open Internet Order, which I don't think is primarily about privacy, it's primarily about regulation of broadband access. And the fact is that the FCC chairman clearly took his direction from the White House. So if the White House is going to be giving direction to regulate broadband access as common carriage, they should also be giving direction to coordinate privacy policy, privacy enforcement throughout the different agencies by having a policy coordinator.
Right.
And
so we need to stop there. I could say more about this, but I want to take a few questions from the audience before we have to wrap up. Anyone? If not, I'll give you my parting shot on the FCC. So I think most people here in the room, well, let me just finish this and take a question. Most people here in the room might hear everything that was just said and think, well, that sounds great. Sounds like the FCC is going to be more active and do things that we've always wanted to get the FTC to do, and maybe the FTC will be more active, and so many people who want more aggressive regulation probably don't really see a downside. Let me just give you a few potential downsides. Number one, the can of worms the FCC is open is, I think, not limited just to broadband providers. There's language in the order that very clearly talks about edge providers, that is service and content companies, being subject to Title II, at least as part of interconnection, potentially in other aspects. And it certainly makes it easier for the FCC to reclassify other services. And indeed, the FCC has been regulating VoIP services that interconnect with the traditional telephone network for years, both for privacy and 911, but also for the Community Assistance to Law Enforcement Act, CALEA, which is what requires them to be wiretap ready. But the logic of the order seems to me to be very clear. In order to justify reclassifying wireless services in general, the agency had to reinterpret what it means to be interconnected, and essentially says if you're interconnected with the internet, you're a covered service. I don't see why they can't use that same rationale for regulating the privacy practices, both commercial privacy practices of, let us say, for example, Facebook chat, video chat, and so on, for commercial privacy protection, in which case the FTC might lose jurisdiction over them, and the FCC becomes a sole regulator. But also, I don't see why Clapper and the FBI, who just said they don't want new legislation to ban encryption, can't go to the Federal Communications Commission. Now, maybe this particular chairman isn't going to give them that, isn't going to ban encryption. But there's no telling what the next chairman might do or what a Republican chairman might do. So, food for thought. Final question here from the front of the audience. No.
I don't think encryption is banned even to common carriers.
Well,
They have to be
being a
wiretap ready, but they
right.
don't.
So,
they're
but how
not
can you be wiretap ready if you don't
It's a
possess?
plug. It's a plug. There's not a requirement that the common carrier provide clear text if they don't have it.
Good clarification. Final question.
So you spent a lot of time talking about the FTC, but they have to go and find their own cases. There's no requirement for registration or getting licenses that might be present in some European regimes. So I really don't see how the model of regulation and enforcement in the U.S. is equivalent with the data protection regimes that are in Europe.
Because my answer to that would be the FTC, problems find the FTC. The FTC is both looking for problems and people file complaints with the FTC. So the difference, I would submit to the contrast you're drawing, is the FTC is dealing with problems and abuse, alleged problems and possible abuses and going after them. In Europe, they're not as focused on going after harms, they're going after regulations and registrations and so on. It is two different ways of approaching it. One is a harm-based, enforcement-based approach, and one is a registration and regulation. I don't know that the European model is better at protecting privacy, but it is more prescriptive.
I don't think it's better at all, but it's not equivalent. So given
Right.
where you got to here by talking about the Supreme Court case in Europe, I don't see how any system based on U.S. law could be equivalent.
But I think, though, that like when they think about equivalence, they're not sort of looking at the registration requirements that a lot of the DPAs have. Like if you have a database, you have to register it, which is never going to happen in the U.S. They're instead looking at the substantive rights, the fair information privacy principles. And that's, I think, what they're saying, which they also saw, in that case, they saw a lack of equivalence. But I think there is, that does map a little bit more closely.
The key word here is gestalt. That's not actually used in the European regulation, but when you read the Schrems decision, it's very clear that it's a gestalt assessment as to whether the U.S. approach is, kind of, sort of works. And in that case, they said it kind of, sort of doesn't work anymore, needs to be changed. But they're actually it's pretty clear that they're not actually focused on those specific formalistic requirements. It doesn't have to be equivalent. That's not the word. The word is adequate. And I think that's the question that's going to be facing U.S. lawmakers. You could, I'll wrap up with this, you could see a perfect storm where after 15 years of inaction, in the next few years you get some court decisions from in Wyndham, depending on how the LabMD case goes, depending on how the negotiations go in Europe. You could finally see some kind of momentum, especially given the whole thing about the FCC, because really, while broadband providers, never liked the CP&I rules the FCC had, everyone else is terrified of being regulated by the FCC and considers that a huge loss. So there's a lot of momentum towards both keeping things at the FTC, restoring safe harbor, and in some fashion constraining the agency's discretion or making its operations more transparent. So something may happen there. We'll see, but we're out of time. So thanks for coming, and thank you to Janice and Aaron.
Well done. Covered a lot of ground
For
there.
you all, we're going to be starting up in less than 10 minutes in the main room. Lunch is out front, so grab your lunches and then the main Magnolia Ballroom.
Well, thanks.
All right,
I'm
thank
glad we
you.
didn't prepare. That would have been a waste of time.
Yeah, no, thank you very much.
Janice, are you going back into the city?
Yeah.